I have long been interested in the Native Land Court, and it always struck me as anomalous and indeed rather strange that the decisions of the Native Land Court and even of the contemporary Maori Land Court have never actually been formally reported. So one of the aspirations of the project was simply to create a series of books in semi-law report form, which would bring these decisions of the court to light and form an addition to New Zealand's body of reported jurisprudence. However, the books are not only law books, they're books of history, and the cases that are included are prefaced by quite long introductory essays in some cases, plus the book has other chapters at the start of each volume reviewing the history of the court, the biographies of the judges, etc. In terms of what is my favourite case, I'm not sure favourite is quite the right word, but certainly the most gripping of the early cases was the court's decision about the Chatham Islands, where there was a contest in the court between an incoming iwi Ngāti Mutunga who arrived in the islands in 1835 and the Moriori people of the Chatham's archipelago. The court awarded the bulk of the land on the islands to Ngāti Mutunga on the basis of conquest, setting aside only small reserves for the Moriori people. The evidence given in the case was dramatic and very graphic. So I think that's the case that stands out most. The most surprising thing that I found has occurred during the work I've been doing on Volume 3, which is the extent to which the court's work was taken up with cases related to disputed wills and successions. The court was given a jurisdiction over probate in 1890, and this became an exclusive jurisdiction for probate of all Maori wills in 1894 insofar as they related to land. This meant that the court became entangled in the same kinds of cases over disputed wills and challenges to wills that so regularly plague the ordinary courts. And in fact, many of the court's most complex decisions and the biggest appeals in the period from about 1900 to 1950 related to successions. This was a quite unexpected development, and we've certainly added a great deal to the stock of New Zealand reported case law on contested wills, something I simply didn't foresee. The lessons that can be learnt have a number of implications, I think. One is to show just the difficulties that can encounter a judicial body set up to control Indigenous interests in land and translate those lands into an ordinary legal framework. That was the statutory task set for the Native Land Court in the original Native Lands Act, and it's remained its prime function throughout. But to carry that out required enormous investment in terms of formulating ideas and principles by which this could be achieved. It was a very difficult process. It was an even more difficult process for the Maori people who were involved in the cases, who had to attend lengthy citizens of the court, retain lawyers or Maori kaiwhakahaere or managers to present their cases, and generally have to be involved in the process in many instances, whether they particularly wanted to be there or not. In some respects, the research that I did confirmed the standard picture of the Native Land Court that have been developed by a number of historians, but there were a number of surprises as well. The notion that the Native Land Court was simply a tool of the colonial state and could, to all intents and purposes, be treated as a part of the executive government, I have concluded is not exactly the case. For all its shortcomings, the court was a truly independent body and defended its independence against the government on numerous occasions. The court also carried out, much to my surprise, quite extensive site visits and retained or paid attention to a lot of evidence that was extrinsic to the courtroom, contrary to what is often said. Another thing that intrigued me and I found more interesting than I imagined are the judges of the court themselves, who were mostly not lawyers, but were a very mixed bunch, drawn from all walks of life, some of them very contentious and eccentric people. So the project revealed that there was a lot more to learn about the court than at first supposed. However, there's more to it than that with the case of the Native Land Court, because these decisions are not simply historical. They live on. They continue to have practical importance in the present day. The Waitangi Tribunal has to invest a great deal of effort in understanding the Native Land Court, and a number of these earlier decisions that I have included in these volumes have turned up in the contemporary courts and are being cited and referred to. Māori people have long been denied an accessible collection of decisions of this court, which impact so powerfully on their history. So these books are essentially historical works, but they have a contemporary resonance. The Law Foundation's support of this project was essential. It enabled me to have a research assistant for a large part of the term of the project. Finding and locating the cases, getting them transcribed is an enormous and laborious task. So without that Law Foundation support, this could never have happened in the first place.